And after all, your phone is usually where the most sensitive info about you and your private life is stored. Cellebrite products can get all of that info and more, and so you'd think that their use in Australia would be subject to the most stringent restrictions and oversight, right? Well, that's not the case at all. In fact, the way that Cellebrite products are used in this country raises some serious concerns for our privacy and civil liberties, and that's what I'm going to explore now. For starters, Cellebrite products are used by a wide range of government agencies, and not just law enforcement. At the federal level, there have been 171 contracts between Cellebrite and various government agencies since 2011. These agencies have included the AFP, the Department of Defense, the Department of Home Affairs, ASIC, the ATO, and more. One of the more controversial contracts is that with Services Australia, which allows Centrelink to use Cellebrite technology in investigations of people suspected of making false claims for Social Security. Another controversial contract is that with the Sports Integrity Unit, formerly known as the Australian Sports Anti-Doping Authority, which has used Cellebrite technology to investigate the use by athletes of performance-enhancing drugs. Now, it's important to understand that these are just the federal agencies that have contracts with Cellebrite, and not all of the agencies who use Cellebrite technology. For example, in 2023, Services Australia admitted that it had shared Cellebrite's phone hacking technology with the Department of Education, as well as other unnamed agencies. We don't know which other agencies are using Cellebrite products, and that's part of the problem. The same problem exists at the state and territory level, where even less is known about the use of Cellebrite technology. We know that Cellebrite has contracts with at least some state police forces, as well as other investigative bodies like the New South Wales Independent Commission Against Corruption. But we don't know whether any of these state agencies are sharing Cellebrite technology with other state agencies, and in what circumstances. Something interesting I learned when I was doing research for this story is that the Australian government is not only a client of Cellebrite, but it also pushes Cellebrite onto other countries. People familiar with the geopolitics of this region might know that the Australian government wields a lot of influence over some of our smaller neighbours. And one of the ways that this manifests is with policing. The Australian Federal Police has a big say in how the police forces of our neighbouring countries operate. And in the last few years, the Australian government has provided Cellebrite products to police forces in countries including Vanuatu, Papua New Guinea, and possibly the Solomon Islands. The AFP also provides Cellebrite training to these and other Pacific nations. Okay, so now that you know some of the agencies using Cellebrite technology, let's talk about the way they're using it. For me, this is one of the most important aspects of this story, yet it's something that most people don't know about. Why is it so important? Because there are very few, if any, known restrictions on the use of Cellebrite tools by these agencies, and this has resulted in mobile phones being hacked on a large scale in this country. To illustrate the point, I'm going to focus on the New South Wales Police Force, because that's the agency that I deal with most as a criminal lawyer based in Sydney. In New South Wales, none of the restrictions that apply to other police powers to protect people's privacy and civil liberties apply to the use of Cellebrite technology. For instance, the cops generally need a warrant if they want to do things like search your home, tap your phone, or install a listening device in your car to secretly record the conversations you have with people. To get these warrants, the cops need to go to an independent authority, like a judge or a magistrate, and present some evidence justifying the warrant being issued. What this evidence needs to prove depends on the warrant being requested, but it basically requires the cops to show they've got a good reason for the request. For example, if the cops are applying for a warrant to search your house, they need to demonstrate that they've got reasonable grounds to believe that they'll find the evidence they're looking for at your house. Now look, I don't want to pretend that the system is perfect, and there are plenty of critics who argue that these warrants are given out too easily, but at least it's something. It provides some independent oversight and it deters cops from making dodgy applications for warrants. Now, when it comes to Cellebrite, there is no legislation in New South Wales, or for that matter, in any Australian jurisdiction, that requires the police to get a warrant to search your phone. And from experience, I can tell you that the cops take the view that if they get their hands on your phone, they can Cellebrite it, without approval from anyone. So how can they get your phone? Well, there are several ways. One is if you've been arrested for whatever reason. In that situation, the police can seize your phone without a warrant if they reasonably suspect that it will provide evidence of the commission of any offence, regardless of how trivial it is. But even if you're not under arrest, the police have the power to take your phone without a warrant in various situations. For example, the police have the power to stop and search you and your car without a warrant when they have reasonable grounds to suspect that you're in possession of a prohibited drug. Now, it's important to understand that there's no minimum quantity of the drug. So if the cops suspect that you've got even just a tiny amount of weed or coke on you, they can search you. And once they search you, they can seize your phone if they reasonably suspect it might provide evidence of what they call a relevant offense, which covers most crimes. An even easier way for the police to get your phone is if they do it with your consent. Now you might be asking, why would anyone agree to give up their phone to the police? Well, it actually happens a lot. You see, most people don't know their rights and they're intimidated by the police. They think that anything a police officer asks them to do, they have to do. And a lot of cops know this and take advantage of it. Now I should add that some defense lawyers in Australia have tried to challenge the status quo, and they've argued that the police actually do need a search warrant to Cellebrite your phone. In doing so, they've relied on a 2014 case from the United States called Riley versus California. In Riley, the US Supreme Court held that the police do generally need a search warrant to search a mobile phone. One of the main reasons for its decision was its finding that searching a phone is more akin to searching someone's house, which you need a warrant for, than searching their person, which you don't need a warrant for. In fact, the court found that searching someone's phone can be even more intrusive than searching their home. Now, if this argument made sense back in 2014, it makes a lot more sense in 2025, given how far the technology has evolved since then. Our phones now hold a lot more sensitive data than they did a decade ago, and with the help of Cellebrite, the police now have the ability to download all of it. But unfortunately, these legal challenges in Australia have been unsuccessful, and the position remains that the police don't need a warrant to Cellebrite your phone. And it's important to add that in my experience, a lot of cops download phones as standard practice, regardless of how trivial the case is and whether they actually think it's going to help their investigation. Now, in some cases, I've been able to persuade the police not to Cellebrite a client's phone, but it's usually up to the goodwill of the individual officer, and that's something we don't always see a lot of. The result of all of this is that the police are downloading mobile phones at an alarming rate in this state. Now, we don't actually know how many phones New South Wales police are Cellebriting each year, because they're not required to report this, but we know from anecdotal evidence that it's massive. To give you an idea, just with my practice, each year I receive dozens of Cellebrite reports of phones that have been downloaded, and I'm just one criminal lawyer of thousands in this state. The other day, I spoke with a colleague who had recently cross-examined an officer at a hearing. The officer gave evidence that she downloads about 20 mobile phones per week, and that's just one police officer in one police station. There are more than 400 police stations in New South Wales alone. So I don't think it's far-fetched to estimate that the New South Wales Police Force is downloading tens of thousands of phones each year. And that's just one agency in one state. Just imagine what the number is nationwide. Now, some of you might be thinking, okay, but the police are only doing this to criminals, right? So who cares? Well, the first thing to remember is that not everyone who the police stop and search ends up being charged. And not everyone who is charged ends up being found guilty. A large number of my clients who've had their phones celebrated end up walking free. Another important thing to know is that the police also regularly Cellebrite the phones of victims and witnesses of crimes. I see this especially in cases involving allegations of sexual assault, where the police will download the complainant's phone to get the messages they exchange with the accused or with their friends about the incident. Now, plenty of times the messages are relevant and definitely should be disclosed to the defense. But there are real issues with the way the police go about it sometimes. Firstly, by using Cellebrite's UFED, the police don't just download the relevant messages from the complainant's phone, but all of the data. Secondly, the police will then often provide the defense with a copy of the entire download of the complainant's phone. Now again, that's helpful for us defense lawyers because it can contain relevant information. But the truth is the vast majority of the data is completely irrelevant and often very private. An example of this happening was in the high-profile sexual assault prosecution of Bruce Lehman a few years ago. In that case, the Australian Federal Police provided the entire Cellebrite download of Brittany Higgins' phone, which even included her counselling notes, to Lehman's lawyers. Some of the phone's content, like text messages she had sent to certain people prior to making the complaint, were clearly relevant and damaging to her credibility. But most of the data was entirely irrelevant or otherwise inadmissible, like her counselling notes, and shouldn't have been served. Now, the police in that case said they gave the defense Ms. Higgins' phone download by mistake, but I've seen several cases where it's been done knowingly. In other cases, the police might not serve the entire download of the phone, but they'll still serve a lot more than they should. For example, a year ago I was representing a guy who'd been charged with sexually assaulting a woman during a Hinge date. When the police served the prosecution evidence on my office, it included a partial Cellebrite download of her phone that contained sexually explicit messages that she had exchanged with another guy that had nothing to do with the case. The messages were never going to be admitted as evidence at my client's trial, but the cops gave them to us anyway. Another major issue is the lack of communication by police when they ask alleged victims to hand over their phones. To give you an example, a few months ago I gave advice to a woman who was an alleged victim of sexual assault and domestic violence by her ex-partner. When she first made the complaint, she showed the police the relevant messages on her phone. After her ex was charged, the cops asked for the phone so they could download the messages. But at no stage did they tell her that they were going to download her entire phone and then give it to her ex's lawyers. So she was understandably pretty distressed when she found out that her ex now had a copy of all of her messages with her friends and family, her photos, her health data, everything. She told me that had she known the police were going to do this, she might have thought twice about handing over her phone to them. It might surprise you to know that what I've just described is actually a pretty common experience for sexual assault complainants. In fact, it's so common that, in the recent inquiry by the Australian Law Reform Commission into justice responses to sexual violence, the advocacy group Full Stop Australia recommended a review of this celebrating practice to protect victims' privacy. Interestingly, the Law Reform Commission didn't adopt the recommendation in its final report. But regardless, I think this is a phenomenon that will receive a lot more media attention in the years to come. The next issue I want to talk about briefly is the lack of oversight when it comes to Cellebrite use. There are laws in this country that are designed to provide some accountability to the public about the use of police powers that undermine our civil liberties. For example, like I mentioned a bit earlier, each year the Federal Attorney General publishes a report that discloses important info about the use of telephone interception by law enforcement agencies in this country. This info includes how many agencies applied for phone tapping warrants, which crimes these agencies were investigating, how many warrants were granted, and how many were refused. So, we can see from last year's annual report that 3,007 interception warrants were granted, of which more than a third were for serious drug offences, followed by violence offences and murder. The report also provides info about the effectiveness of telephone interception, such as how many people were arrested on the basis of evidence obtained by phone tapping, the types of offences that these people were arrested for, and how many of them went on to be convicted. So, the same annual report from last year discloses that information obtained under phone tapping warrants led to 1,592 arrests and 1,060 convictions. The Commonwealth Attorney General has a similar reporting obligation for other police powers, such as stored communications warrants, which are what the police use to access text messages stored by providers like Telstra and Vodafone, and surveillance device warrants, which are what the police need to install listening devices, hidden cameras, and tracking devices. Here in New South Wales, similar reports are prepared each year about the use of various police powers, including surveillance devices and covert search warrants. Now, in my view, the use of Cellebrite technology to download your phone is far more invasive than all of the police powers that I've just mentioned, yet none of the mechanisms designed to provide accountability for their use apply to Cellebrite. As a result, we have no idea how many phones each agency is celebrating per year, what their reasons are for doing it, or how effective it's been. Okay, so the last topic I want to cover today is what happens with all of this highly sensitive data once it's downloaded from your phone. Now, I should make clear that everything I'm about to tell you is based on my own professional experience and research, and not any law or policy. And the simple reason for that is that there are no laws governing Cellebrite use in this country, and no government agency has published policies about Cellebrite use either. In fact, from conversations I've had with federal and state police officers, it seems that no policies or guidelines even exist, and this raises some real concerns. For example, I'm not aware of any requirement for the cops to destroy the data they've downloaded from a phone after any period of time. And this is not just for phones of people who end up being found guilty of a crime, but all phones that are downloaded. So let's say the cops celebrate your phone because they suspect you've done a crime, but after they go through the downloaded data, they realize they got it wrong and no charges are laid. Well, they don't have to delete the download of your phone and it'll be stored on their database indefinitely. The same goes if you're an alleged victim of crime. To use Brittany Higgins as an example again, the Cellebrite download of her phone sat with the police long after the criminal prosecution of Lehman had been discontinued, and all 56,000 pages of it ended up being subpoenaed in entirely separate defamation proceedings brought by Lehman against Network 10, and then in defamation proceedings brought by former Senator Linda Reynolds against Ms. Higgins. Another issue is that there are practically no constraints on how the data that's downloaded from our phones can be used. So let's say the cops are investigating a robbery and you're a witness who recorded some videos of the crime and then sent them to your mates. The cops then ask if they can download the videos and messages, and you, not knowing your rights, agree and give them your phone. The police then celebrate your phone and see some messages showing that you shared some pills with some mates at a music festival 8 years ago. Well, in theory, there's nothing stopping the cops from using that evidence to charge you with drug supply, even though it has nothing to do with what they were investigating in the first place and you weren't even a suspect. There also doesn't appear to be anything from stopping the cops from sharing the data that's downloaded from our phones with other agencies, and with those agencies then sharing the data with other agencies. So if your phone is celebrated, it's almost impossible to know where your data will end up and who will get to see it.